All right, so Mr. Ball, your client did not serve Ms. Bliss with the documents that were filed, at least that's my understanding.
Yes, Judge, in preparation for today's hearing, I did see a number of pleadings filed by Mr. Benton, none of which has been served on my office.
And the other thing I want to make you aware of, Mr. Ball, is that we have local rules as to the length of affidavits, and the affidavit that was filed by your client was substantially, I believe, longer than what's allowed. So just to make you aware of that. So with that, Ms. Bliss.
Your Honor, I would be requesting a 2-week continuance today. Again, there was maybe 15 or so pleadings that I had realized was filed yesterday. Granted, they were filed, I believe, on the 16th based on my notes, but again, I did not receive service of those. So I am asking for a 2-week continuance. There is an immediate restraining order in this matter. I do have an extension with me today to hand up to the court if the court orders that.
Mr. Ball?
Thank you, Your Honor. I do object to the extension of the restraining order, as this is a committed intimate relationship petition. The children are not, there's no claim involving the children in the petition. And the restraining order does involve the children. The mother did move to Wyoming. Just
and Judge, at this point, I'm going to object.
Hold on. Yeah, I'm not, you're offering information that's not a part of the record at this time.
It is part of the record. I'm talking about the petition, Your Honor. And so that's.
And Judge, I would argue that his argument before the court today is not properly before the court.
Yeah.
Okay, well, I object to the restraining order, and if I'd be allowed to finish for a minute, then that's what my objection is that this case doesn't involve children, and the restraining order involves children and the mother's in Wyoming, which she signed her declaration and shared in Wyoming.
Ms. Bliss?
And I don't think that goes to the matter that's before the court today. Before the court today is my request for a continuance based on failure to serve of Mr. Benton. I think that those are substantive issues that need to be addressed at our hearing in my request of 2 weeks.
My request is to set it out on October 22nd. We filed a petition for a parenting plan, which should have been filed with the CIR allegedly. So we're filing that motion today. So we'd ask that everything just be heard on the 22nd.
And I have no objection to that, Judge. I think for judicial efficiency, that makes sense.
Let me see your restraining order.
I do have October 15th listed on there. So if you can scratch that out and put the 22nd. And Mr. Ball, I did email you that just a few minutes ago.
What was it?
The order extending the restraining order.
So at this time, I am going to go ahead and sign the order extending, set it out to the 22nd, changing that on the extension. That'll be October 22 at 9 a.m. Mr. Ball, I understand it's not what you had requested, but can I put approved via Zoom, or what do you want for your name?
Oh, yeah, it's approved as a form via Zoom. Thank you.
And Judge, I would just note on page 2 of that document, I did leave the service section unmarked, as I didn't know if Mr. Ball and or Mr. Benton would be present today. So at this time, I would ask that service not be required, as they are both present in court today.
Mr. Ball, any objections to that?
Same objections.
Marking the box that service is not required. So this, again, is being set over to October 22, 2024 at 9 a.m. And we'll take the matters up at that time.
Very good. Thank you, Judge.
Just a second.
Thank you.
All right, this matter comes on for temporary orders, and those were noted on by Ms. Powers. And I should ask Ms. Powers, is your client Alyssa Swafford present?
She is not present.
Okay. All right, so the orders were filed, or not filed, requested, and a request to continuance was made by Mr. Swafford in regard to this. So Mr. Swafford, in regard to your request for continuance, how long were you requesting?
Ideally a month.
Okay. That's your request, it's 1 month.
Yes.
Ms. Powers?
We would agree to a 2-week continuance. We mailed everything out to Mr. Swafford on September 4th. It was difficult getting service, but we did get an order allowing service by mail. It was all mailed to him September 4th. So we believe another 2 weeks is plenty for him to be able to respond. We are asking, though, that if the court sets this over, that the court please order a hair follicle test be done by Mr. Swafford within 24 hours. My client is willing to pay for that. We would recommend occupational health, but if he uses somewhere else, that's okay as well. But we'd ask that be done within 24 hours. And we'd also ask the court to allow my client to have visitation this weekend. She will be traveling and staying here in Portland with her family and would like to have the boys over the weekend. Other than that, we're fine with a set over.
Mr. Swafford?
I am in between counsel at the moment. Part of the continuance I asked for, but I don't know what grounds she has to require me to take a hair sample test anyway. And I've given the boys to her family or my in-laws on every occasion that they've asked for them, but each time that I've done that, they have resisted and tried to interfere with giving them back to me. And they've actually had to track them with their phones to a museum in downtown Portland when they were supposed to have met me in Woodland the last time, or not this last time, the time
Okay,
before
so
that.
you've had trouble. Okay.
Yeah, and and before that, right after my grandmother had died, my mother-in-law created a scene at my grandfather's house.
Okay, I don't want a lot of detail. Are you objecting to this weekend coming up or?
No, I don't see any problem with it.
Okay.
Unless,
So it sounds like there's no objections to the visit over the weekend. And then in regard to the hair follicle test, I'm going to reserve on that at this time. You can bring that up in 2 weeks. I am only going to set it over 2 weeks. And this has been pending for some time, so it needs to get going moving forward. So I'm going to set this over to October 15th at 9 a.m.
Thank you.
And then Ms. Powers, if you can go ahead and put an order together about the weekend and get that to Mr. Swafford and then submit it to me for signature. Please note it's from today's docket and what it's, in regard to, so that I know what I'm looking at when I see it.
If Mr. Swafford won't sign off on the order, how does the court want me to submit it?
You can just put present in court.
Okay, perfect. I will do that. Thank you.
Okay, so that's it for today.
Amy Powers appearing for Ms. Swafford. Ms. Swafford is also on Zoom today.
All right, and I take it you're Anthony Swafford?
I'm Jason Anthony Swafford.
Oh, I apologize. I used your middle name. I apologize. Okay, so Mr. Swafford is here present in the courtroom. All right, so this matter was on for a temporary order, but I did not see any response from Mr. Swafford. Am I saying that correct?
Yeah.
Okay. So I just wanted to check in with him to see if he intended to or what's going on.
I would like to ask for a continuance again. The original continuance I asked for, the 4 weeks. I didn't know, but my attorney or my representative, the military legal officer from JBLM is on leave until the 28th, and I won't be able to speak to him until after that.
Are you able to hear him, Ms. Powers?
I am. Thank you.
Okay. You said the 28th of,
This month.
okay. Ms. Powers?
Well, we were here on October 1st, and at that time, Mr. Swafford requested the set over to today, which we had agreed to. If we'd prefer to proceed today, but if the court is going to set this over, we would ask that the court make some sort of interim decision about visitation. And right now, we're just asking for visits every other weekend and liberal phone calls. And a once a week video visit, which is what my client's been having. In November, we'd like to increase the time that Ms. Swafford is having, but between now and then, that's what we would ask remain in place. And additionally, we're requesting that Mr. Swafford complete a hair follicle test. My client is willing to pay for that.
So first, in regard to the visitation schedule, any objections to that? And you have to be very limited in what you can say because I don't have a response from you.
I don't have any objection with that, Your Honor.
Okay, so he's good with that. What about the hair follicle test?
I don't know why there's, why they're requesting that. They don't have any reason
Okay.
to.
So he's not in agreement with the hair follicle test at this time, Ms. Powers. So in regard to that, I'd prefer on that particular issue that he's going to have counsel, that he wait for his counsel on that issue. But as to the visitation, it sounds like he's in agreement with that part of it. So if you can put together an order.
Yes, we did an order on hearing on October 3rd, which was entered with the court. I guess I'll just send over another order on hearing that just extends that order basically.
Right, that's all I need.
Okay, and what day is the court setting this over to?
So does the attorney not return until the 28th?
That's correct.
Okay, so
Unreachable until.
is that attorney actually going to be representing you, or is it just somebody you're going to be talking to? I'm just trying to figure out scheduling. That's all I'm trying to figure out.
He will be representing me, but I won't be able to meet with him until after that date or on that date. But I've spoken with him before. I was represented by Nicole Dalton. I was working with him prior to that, but he was.
Okay. So if he doesn't get back until the 28th, my thought is to just set it over to November 12th. Ms. Powers?
My preference would be the 5th. I have Wakaikam docket on the 12th as well. And so it would be difficult. So I would ask for the 5th or the 19th. But we are asking for temporary spousal support and don't have orders in place. So I am concerned about going out too far.
Okay. Well, let's go ahead with November 19th. I appreciate the request regarding spousal support. Just we can look at if that's granted, make sure to raise that it's been set over because of Mr. Swafford.
On that, Your Honor.
Okay, I don't want you to say anything at this point, okay? I don't have anything in writing. I have to limit as to what you can say, okay?
Okay.
Okay. So if you want to reach out to Ms. Powers to reach any agreements, you certainly can talk to her.
I've attempted to do that, but I didn't get any response.
Okay. So let's go ahead and set this over to November 19th. Does that work for you?
Yes.
Okay. November 19th, that'll give counsel for Mr. Swafford an opportunity to appear. So that's what we'll do.
Thank you.
Thank you, Your Honor.
Thank you. All right, any other agreed continuances?
Judge, I think I have one with Miss Dow on number 7, Anderson and Einerson. We never received Mr. Einerson's response until it looks like about Friday afternoon. Given the issues that were raised in that response, my client is adamant that she would like to reply. Certainly, we had already set this over a couple of weeks at Mr. Einerson's request. Somewhat surprised to get the pleadings late Friday, but my client does have a chance to reply to that. And we're asking to set this over to whatever the next available docket is, whether that's the 8th, the 15th, or the 22nd.
Your Honor, I don't object to that. There's an ongoing CPS investigation involved here, and we would really like to hear back from them before we make any changes to the parenting plan.
Any idea on the timing of that?
I I would love to have my crystal ball shine right up and get an answer from them. It was still ongoing as of, I believe, a week or so ago, when some things happened that indicated they are still actively involved.
Well, and I'll give you some input on that, Judge, and that's part of what we need to discuss in the reply. This has been open and largely stagnant since the very beginning of July. We keep getting, again, unfortunately, these investigations that are largely unfounded. We certainly think Mr. Einerson has a hand in that, but given the fact that this has been open since early July, nothing's happened. My client understands that it's likely to be found unfounded in the report from CPS, and anytime they don't really actively engage with the participants, I think that's a pretty strong indicator it's not going to go anywhere. With that said, I can certainly not confirm that, but that's the suspicion now. I don't think it's going to amount to anything, but nonetheless, probably is appropriate to take that up on a reply, which is why I'm not overly concerned about it. I think if we set this to the next available docket, there may or may not be information from CPS, but my understanding is it's likely to be unfounded.
So what I'm going to do is I would like to have, information, and I understand what's being argued. I understand it's been pending for a while. So what I'm going to do is I'm going to go ahead and set this over to October 15. Okay, go ahead.
Thank you, Your Honor. Sportswear, I do represent the petitioner in this matter, Janelle Anderson. Here on my client's motion pertaining to various tweaks we're seeking or adjustments to the existing parenting plan that was entered back in August of 2023. In addition to getting some child support established, as there's currently a joint parenting plan and a vast disparity in these parties' incomes. So starting with what's most important to my client, that would be on this parenting schedule. I don't see that Ms. Kale is present today. She was at the last hearing 2 weeks ago, asked that this be continued. Nonetheless, I think we can proceed without her presence, as we have the written report, and both parties reference that in their pleadings. So I guess that's number one housekeeping measure. As relates to the existing schedule, again, it's 50-50, but there's back and forth. You've got dad who lives in Woodland. My client resides in Battleground. My client tells you it's about a 35-minute trip both ways. Take the kids to school, take the kids to their sporting events. And based on the way the parenting plan is structured, there's a lot of kind of hopping around with the schedule. Paragraph 8 states that the kids are with my client Wednesday at 4 to Saturday at 4, and with Mr. Einerson Saturday at 4 to Tuesday at 4. And then it goes on to say that Tuesdays and Wednesdays are essentially flop between the parties. So to make it, again, it was Commissioner Carmey's, I think, desire, at least intent, to make that exactly 50-50. And that's the way that they did that to measure that out. We're asking essentially, again, based on the back and forth for the kids, the ages of the kids, that just be streamlined to a simple week on, week off. I think that's easier for the parties to accommodate schedules around that. It's easier for the kids to know whose week they're going to be with dad, whose week they're going to be with mom. And again, it was referenced and recommended in the GAL report that maybe simplifying things for these kids and the parties alike would be beneficial. So we're asking to adopt that week on, week off schedule, again, for efficiency purposes, which we think would make life easier for these kids. As it relates to the second request, again, this has been somewhat of an issue since last year. It's related to sports. Again, I was not representing my client at that point. She was operating pro se. Mr. Einerson did have counsel, although it was not Ms. Dow. So I'm not sure what the intent of this was or what a lot of the argument was based on. But basically, you're giving dad unilateral decisions and sole decision making when it comes to these sports. Court specifically ordered that the kids attend and participate in extracurricular activities through the Woodland District. They've done that. My client details for you that initially, prior to these parties going to court, they had agreed and had been under the stipulation that basically, let's let the kids do sports in moderation. And then as they get older, again, these are still younger children. As they get older, they can largely adapt to see what they like. And we can kind of pursue that at that point. Mr. Einerson, since being given that provision in paragraph 14, has unilaterally signed these kids up for everything. My client details you and goes into kind of painstaking detail about what that has resulted for her. She's taking the kids from Battleground to Woodland, Woodland back to Battleground. Two of the kids have activities and are on different teams. She has a 16-year-old child who plays football and rugby in Battleground. So she's literally spending significant amounts of time with these kids, shuttling them back and forth from Battleground to Woodland, Woodland to Battleground. The reality is dad lives right down the street. GAL gave significant input on this. I said this has been an issue. I said that mom is basically a taxi service for these kids, running them to various activities. Meanwhile, dad's signing them up for literally everything. Kids played soccer in the fall, signed them up for basketball in the winter, baseball in the spring. And my client has gone through and told you what the result of that is for soccer season alone, which was last year, August through November. She's been responsible for 23 of the practices and 18 of the games between them. The way just the schedule worked, didn't work that way for dad. He's doing much less of the transportation. Basketball, the kids fortunately were on the same team, so it minimized that to some degree. But come baseball season, and again, she's essentially held hostage. I signed the kids up for baseball, you got to take them. That's been dad's mentality. I'll get to the issues with that in a moment. Between March and June, again, she was responsible for 14 of the practices, 26 of the games. Meanwhile, her other child's in rugby, and she's going back and forth trying to accommodate all of these different practices and game schedules. GAL states in this, again, this was, again, if you reviewed Ms. Kale's report, somewhat of a focal point for her. She did recommend that, quote, the 3 children should be registered for extracurricular activities and or team sports in the Battleground School District where they reside with their mother. The change should begin following the current baseball season, which the boys are currently enrolled. Report came in again the end of spring, the end of school year last year. We filed this motion. Initially, my client meets with me. We filed it in August, roughly almost exactly 2 months ago. And what happens? We start getting these CPS investigations. My client's surprised by that. Mr. Einerson, again, unabashedly says, yeah, I'm the one that's largely responsible for that. He's called in at least 2 of those. And on the 3rd one, he knew the circumstances, but still thought it wise to contact CPS. And we have unfounded information. CPS reports, we provided you the latest, although it takes 45 days to issue a report and make recommendations. The caseworker says these are unfounded. On one occasion, there was no bruising. On the other occasion, again, that was dad who is attempting to use CPS as a hotline to assist him in custody determinations. And again, that's kind of the attitudes we have here. And we've also provided you information from the Our Family Wizard app, which shows dad who is completely likes the unilateral control he has over this. Nope, I've signed them up for baseball. You're taking them. Nope, I've signed them up for basketball. Nope, you need to take them to the jamboree, even though he's given my client absolutely 0 input. I don't care. And again, this is the problem in some of the abuses we have in this. I don't care if it states under paragraph 14 that he can sign the kids up in Woodland. And at the time, the court wasn't anticipating any abuses to that, and abuses have occurred. You got a dad who then realizes that he's on the verge of change, who starts contacting CPS, making these allegations. All of them are unfounded. And I think the last one is very important, related to Reese, who is not his child. That's my client's older child. He knows where Reese is at. He insinuates to that. Reese is at one of Mr. Iverson's friends' home, because the boys are close and good friends. Knowing that, he still decides that he's not going to participate in anything, not going to respond to sheriff's calls when they try to communicate with him. Insinuates to my client he knew where Reese was the whole time. But we have constant gamesmanship to that effect, in which one parent is exerting control and not parenting in good faith, and it's been problematic. I think the signs are clearly obvious here. We've got somebody who just simply doesn't want to cooperate to get things done, and that's unfortunate. Telephone contacts are in that same vein. That's very liberal. States basically that it's each parent shall be allowed to talk to the kids nightly via telephone video chat when the children are with the other parent. What does Mr. Anderson do? Well, as soon as the kids, and the exchanges are at 4 o'clock, my client gets the kids, and by 6 o'clock, he's calling the kids and keeping them on the phone. Granted, he's just seen them. They've been in his custody for several days, upwards of 2 hours. So he continues to micromanage that. On the other side of the coin, my client will make a call and he'll say, nope, you should have scheduled it first. You're not going to get that. We need some more stringent, I would say, provisions in place that phone visitations or Skype or FaceTime visits be every other night, again, to take away from a lot of these abuses. It's very transparent to see what he's doing, very easy to see what his motives are for this. And unfortunately, it appears to be that of control and possession of these kids. They're both parties' children, they're not just his. And I don't know that he's got that message, but nonetheless, that's the frustration of my client. Finally, we are asking for the child support. We provided you information now on 2 occasions. my client's declaration as well as under seal that shows she's making about $1,500 per month. I think it's interesting, although we asked for that, we're certainly willing to give the deviation for the joint parenting plan. Mr. Anderson makes about 4 times the amount of my client. He's got various forms of income through a disability, through the VA and through the National Guard. He doesn't disclose that. It strikes me in his declaration, he says, well, as it pertains to child support, I guess I'll only provide my financial information if the court requires me to do so. Well, of course, the court's going to want to see that. It's part of the motion for child support. My client's income is what it is. He acknowledges that, but then says, again, more gamesmanship. I'm not really going to provide you any of my information unless the judge orders me to do so. So here we are once again kicking the can. This has been problematic. This has been the attitude that my client has kind of come up against for the better part now of 14 months or so since this action started. It needs to stop. Ms. Dow and I and our offices work very well together. I'm hopeful that we can make some steps towards this and overcoming some of this. But between the attitudes about child support, the attitudes about CPS and using them basically as a hotline to get his way and push his interest in this parenting plan, the attitudes about the sports, the attitudes about the visitation, telephone contacts, again, show a guy that's just obsessed and consumed with the control aspect of this, and it needs to stop. We are confident the court does adopt what we are proposing. That will help curb some of that. My client has essentially played along. She's spending significant amounts of fuel every month just in transporting the kids back and forth, while dad, although he's making 4 times what my client is, doesn't have to do that, and frankly rebels in it. We are asking, this is certainly based on the procedure of this, we are asking for contribution fees and costs of $1,500. I'm certainly not blaming Ms. Dow for this, but when I state that this was filed back in August, that was after we got wind of the initial CPS allegation. We held off. We wanted to have this motion heard prior to the kids starting sports in the fall. We get the CPS investigation. Again, that goes nowhere. Not surprising. We're on the verge of getting that unfounded letter. Dad files another one. This gets kicked out further. We had agreed to the offices to have this heard on October 1st. Did not get any responsive pleadings until I believe the Friday before that. Had to bump it again another 2 weeks to today's date. I just don't think it's in good faith. And again, I think this is a lot of the games that Mr. Anderson traditionally plays and historically has done. Again, pigeonholing my client into a position of last minute stuff, and again, accommodating whatever it is he wants. My client did tell you somewhat in jest, somewhat literally, that as it pertains to these sports and the concussion, or at least the head injuries, the sickness that dad is now consumed with, we're fully anticipating more CPS investigations based on that type of nonsense. I think the only way to curb that is to make a point explicitly clear to dad that unless it's a genuine, legitimate concern, he is not to use CPS as a means and a tool to further his ends in this parenting plan case.
Ms. Dow?
Your Honor, counsel has made a list of Ms. Anderson's complaints about working with her ex-partner who has stepped up to support their children in both educational and recreational activities. The Guardian Ad Litem covered these issues pretty extensively about the fact that the parties have conflicting ideas about how things should be done. They're not working well together at the moment. There is a more immediate concern here, and counsel has characterized my client's contacts with CPS as an attempt to manipulate the parenting plan. He's made no secret that he would like to see the children primarily living with him. That may be a matter for trial. He's very concerned about what's going on in Ms. Anderson's household. The Guardian Ad Litem recommended in her report that the younger children not be left alone with their older brother. She didn't specify exactly why that was. The information that he was given that prompted his CPS report that involved this older child was that an altercation took place between Ms. Anderson and her son that included threats of violence on her part and kicking her 16-year-old son out of the house. The CPS investigator told him that another anonymous report about this incident had also been filed. This is not just him reaching out to CPS. Since he filed his declaration, he has also had someone else who knows his family reach out to him to warn him that CPS is going to be contacting him again about another incident. He doesn't know what this is about.
Hold on. What's that?
I would just object to anything not containing the pleadings or constituting hearsay.
Yeah, it's not in the pleadings, so it won't be included here. Go ahead.
Okay, Your Honor, he doesn't know what's going on with this situation, but his main concern is about how she's handling it and the impact that this is having on the youngest children. The Guardian Ad Litem report noted that throughout he has been concerned about how she handles things with the children, about her decision-making, including her decision-making about partners. He would like to see at this point that we maintain the status quo until we find out what is actually going on in her household. Now, we're only speculating about what CPS is doing, but whether or not to possibly re-involve guardian ad litem is a matter that we would like to maybe leave up to the court. So as far as that issue is concerned, we would like to maintain the status quo. As far as the child support issue is concerned, we still need full financial information from both parties. Council is slightly misrepresenting what Mr. Einerson has said about providing financial information. It should be fairly straightforward. He has an employer. Ms. Anderson has income from and part ownership of a family business. She receives housing and possibly other benefits in lieu of salary from that business. Apparently she has a cash sideline reselling items. We need more information to set child support. And we are asking that the court simply order the parties to submit their information. My client is not waiting on a court's order. He doesn't have a problem with it. His is straightforward. It's Ms. Anderson's information that we're concerned about getting. So we are asking that the court reserve on all of this until we have more information, both from CPS, possibly re-involvement of a GAL, and receipt of financial information from Ms. Anderson. She submitted some images of bank statements that shows she is receiving $1,500 a month. There is no way she is supporting herself and 3-4 children on $1,500 a month. She's getting more income from somewhere, and we just need to have it documented.
Counsel?
Yeah, I'll start with the easy parts, and that's the child support. If you look at his declaration, it states, if the court orders that we revisit child support, both parties will need to supply accurate financial information for review. I can certainly supply mine, and Janelle should do the same. But he doesn't supply his. He doesn't provide any worksheets. This case has been pending for over a year. Ms. Dow is now his third attorney, and at no point have they ever requested any financial information or made these responses outside of today. Child support was reserved last August, and again, prior to both current attorneys' involvement, to collect that information. It was never disputed that my client literally works in a mom and pop grocery store in Battleground and doesn't earn significant funds. The court knew that back in August. There's been no speculation. There's been no information provided since then to dispute that. Her income, if you impute her at an income, again, is going to be pretty close to full-time minimum wage, would be my guess. Again, that's certainly not borne out by anything that Dad has provided. If he has his information, it's so easy to provide, why didn't he? And again, that's part of it, and it is. I don't know how we can quantify that as anything but gamesmanship. If we look at the timing of this, again, the GAL report was submitted in the spring, in March to be exact. Fast forward to June, and Dad starts making these CPS calls. Interesting part about this, what he doesn't tell you, is there was a CPS investigation against him related to Reese back in 2022, and I believe my client tells you was called in by the Woodland School District. So it seems completely disingenuous for him to suddenly, after the GAL report is published, start making these CPS calls, 3 of them, or at least be involved and have his hands in on 3 of those. And now, oh, by the way, have some information from somebody, again, outside of the scope of the declarations that says, well, there might be another one. This is Dad who's organizing this. This is Dad who's spearheading this, and it should not be tolerated and permitted. We've got Ms. Dow who argues that we need a new GAL information. This is information that's pretty recent when you look at it. Again, we talked about modifying things back in July. We scheduled the hearing back for, I believe it was early September. Here we are now in October, and we still don't have any resolution. Dad says, oh, we don't know anything about CPS, but we do. We've given you the information directly from the CPS investigator that states, again, that the case will be unfounded.
Your Honor, if we're objecting to hearsay, I will object to that as well.
We can't get any information from CPS outside of what they've given us in the written records, and this is it.
So, Ms. Dow, it's in the record, it's business record. What are you objecting to?
It is my understanding that the statement is being offered in support of a piece of evidence that the report was unfounded, and we have not seen that as far as I know.
Part of our reply submissions that say from Crystal Hughes, DCYF. Also, I do believe it comes by email talking about the letter. You will also be getting an unfounded letter in the mail. So that's from DCYF. I think that's pretty reliable. And nonetheless, we have submitted it. So we do have the information from CPS, pending more allegations made by Dad. It's all there. We have it. We're just asking for those changes. And again, I'm somewhat surprised that we have an individual who's hanging on so tight to these things, saying no, 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 going to these types of measures. And this is just this is symbolic of somebody who just wants control over these kids, control over the atmosphere, control over the proceedings, and that's not best for these kids. These kids are certainly feeling some of that to that extent. What we're requesting is reasonable, is in line with the GAL report, and it's high time that we do get some child support established so we can make sure that these kids are in equal parity at each parent's home for child support purposes.
So my question is this matter set for trial?
No,
Is it being noted up or what's?
we still have to go through the MSC process. It's a
Okay.
case where I was involved initially last November, I believe, reached out to then attorney who was on, that was his first attorney. We set it. We had a date for mediation. I believe it was in December or January. That attorney put in her withdrawal notice. Ms. Petrie got on board. We discussed the same thing. It was agreed, let's see what the GAL comes in with. We discussed that throughout the course of the summer, and now we have this down. So we still, by rule, have to go to an MSC or some kind of a mediation before we go any further, now that hopefully we have all the information.
And Your Honor, my client and I started discussing how and when we would set this for trial as recently as yesterday. Clearly, this needs to go in front of the court as a trial with witnesses.
Yeah. All right, so here's what I'm going to do. As far as appointing a new guardian ad litem, unfortunately, we don't have the prior guardian ad litem. She no longer is doing this work. And so that makes it difficult. But at this point, the court doesn't see any need for another guardian ad litem. So the court's not going to appoint a new one. The court understands the guardian ad litems, and I've said this many times, recommendations are just that, recommendations. But this is a matter that needs to get to trial, and I understand the MSC and that, but what I'm looking at this point to make a change also, at least a significant one, doesn't make sense. So in regard to the existing schedule, I am not going to change the existing schedule. There are some issues that are out there. The court understands that. Doesn't sound like that they haven't been substantiated at this point, but at the same time, the court doesn't want to change it, and then it goes to trial and it becomes another change. That's hard on kids. And so I'm not going to change the schedule at this time. In regard to the decision-making on the sports, the court finds that the sole decision-making is being abused, and that a different process needs to be figured out. So children may participate in one sport in the battleground area in the fall, or if dad decided fall and mom needs to decide spring, whichever. I'll leave it up to that choice of the mother at this point. And she'll have one sport for the spring in Woodland. Going to split it up. Parties can't agree. That's what's going to happen. Unless the parties agree in writing to additional sports.
It's basically just alternate seasons.
Correct.
Okay.
This can be switched to the opposite if that works better, as I indicated, for the mother given the other child. The language regarding phone calls shall be changed to phone contacts with the children every other day at reasonable times and durations as to not impose on the other parent's residential time. The language as stated can easily be abused. The court again finds that it's being abused, and that's exactly what's happening. So the language will get changed. In regard to child support, the court does not necessarily see that it has complete information today. But at the same time, it should not just be sitting out there and not being addressed. That makes no sense either. So court orders the parties to submit their information. And I'm going to go ahead and set the matter of child support on for November 19 at 9 a.m. And at that point, I want everything filed by November 5th.
As a precursory ruling, if me and Ms. Dow can get together, exchange that information prior to that, would you be inclined to grant a deviation for the joint custody plan, I'm assuming?
Correct.
Okay, and then each claim exemptions reasonably?
It would be standard.
Okay, all right. I think we could probably do that.
Okay.
I think so too, Your Honor.
Okay.
Then do you want a presentation on the 19th, or do you want a separate presentation, Judge?
So we can do a presentation on earlier if you want, or I find that Ms. Dow and the two of you tend to do okay. So I guess if we want to go ahead and put it on November 5th for a presentation, if you get an agreed order, then great.
Okay, very well. Thank you.
Your Honor, may I just clarify here for a moment? if we don't have an agreed order, you said you have set the child support decision for 11/19.
Correct.
Setting a presentation date for 11/5. What would you like to do for a presentation date if we cannot reach an agreed order?
Just the stuff related to the parenting plan, the phone calls.
So, yeah, it's the
decision-making.
parenting plan issues that are on for 11/5. 11/19 is the child support. What I said in regard to child support is I wanted everything filed by the 5th.
Thank you for clarifying that, Your Honor.
Thank you.
All right,
Sorry.
thank
My
you.
you.
Report that was filed yesterday afternoon. Is there anything more today?
I don't think so, Judge. I think this was just a tracking mechanism. It's a pretty long report. I did have a chance this morning to review that. My client did last night. Haven't had the chance to speak directly to him about the implications or where we go from here. I'd like to do that and then start put some ideas together for resolving this case or setting a trial.
Ms. Holder?
Yes, Your Honor, I've had a chance to read it, as had my client. I believe it would be appropriate for Ms. Fellows to at least give a rundown of the report today. There are some things that I believe require some immediate action.
Ms. Fellows, go ahead.
Yes, I did make some specific recommendations in my report due to all the information that I had. I am recommending that mom remain the primary parent, that there be 3B findings against dad, that dad, and specifically that dad engage in and complete a psychological evaluation with a parental risk component, and that he also, there be testing for bipolar disorder as well, that the prior GAL from report from Tina Day, the GAL report that I just filed, and collateral contact with me be a part of that evaluation. Also that the father engage in domestic violence evaluation. He had a prior evaluation by Olivia Lovely. He never truly completed the 52 weeks that had been recommended. And so at this point, given the information that I have, I am recommending that he actually do another updated evaluation, and with all of that collateral contact, Tina Day's report, my report, and collateral contact with me, and complete the treatment. Those are the two biggest things. And a large part of it is that in my recommendations is that if he does not complete those within 90 days, that his residential time be restricted, be suspended until further order of the court. I do have serious concerns also about the father using disparaging comments and talking about the mother and being extremely inappropriate, and that needs to stop, absolutely needs to stop. There is absolutely no reason that there is any discussion, any questioning, anything about the mom, any kind of disparaging remarks or anything of the sort. The father should not be saying anything of that. It is in the orders, however, he has not been following it. As in my report, there was that exchange in June where mom was also throwing out disparaging remarks, but that's the only time that I have heard of her doing such a thing at this point. So that's where I'm at this point, Your Honor.
So counsel, I want to make this statement first, that this is not to be offensive, meant to be offensive to the Ad Litems. They are recommendations. And if somebody is looking to have those recommendations adopted, they need to file a motion and bring it before the court. Quite honestly, I have not had a chance to read the report. I was preparing for the entire docket yesterday. So I've not had any opportunity to do that. So at this point, the only thing that I see that, as far as the report being filed yesterday, the disparaging remarks, nobody should be making disparaging remarks. That's on both sides. So other than that, Ms. Holder, I won't be moving forward on anything else. Is there something else?
Yes, Your Honor, there was something rather concerning that I do believe needs to be addressed immediately in Ms. Fella's report. Page 12, line 10 through 12, for specific reference. There was an instance where one of the daughters had reported to both her counselor and father that her younger brother had inappropriately touched her in the
Judge,
home.
I'm going to object. Again, we got the report at 3:38 p.m. yesterday. I haven't had a chance to talk to my client. We're arguing well outside the scope of any pleadings at this point, and I think you've already given your order on that. Otherwise, we're going to have a full hearing today with very insufficient notice and time to actually gather our thoughts and make a request via a motion. I think we're completely way far abroad of what the point of today is.
Ms. Holder, bring your motion a short in time or whatever you need to do and get it before the court. But at this point, I didn't receive it until the time that's been indicated. Mr. Zandy's already indicated he hasn't read it. I haven't read it. And I'm not going to just make a ruling. I understand it sounds like there's a potential issue. But again, if it is an issue, then maybe talk to Mr. Zandy and see what you can potentially do. I don't know, but I asked for motions. If this was a urgent set over for a month, that's one thing. But this is a report that's been pending for a while, as any final report is. And so I'm not going to be taking any action today.
Yes, Your Honor, understood.
Thank you, Your Honor.
Thank you.
Thank you.
Please put your entire name on, or you will sit in the waiting room and I won't be admitting you.
Okay, thank you.
All right. Do I have Keegan Golahan?
Yes, Your Honor.
Okay. All right. So this is on for, first off, Ms. Demeter, I still do not have a restraining order. So.
Your Honor, we received back a signed copy.
Okay.
After the last hearing, we submitted it and received it back with your
The
signature.
dates were wrong on it, right? Yeah, the dates were incorrect. Let me pull it up real quick. The order that was from September 19 extended the matter to August 20th at 9 a.m. So the date was incorrect. It covered a time frame from a prior one, but it didn't cover the current one time frame.
Okay. I apologize. The one we got back on somehow. Okay. I see that, Your Honor, that you signed on May 19th. Well, okay.
Okay. All right. So with that, this is on for purposes of the interim review. And the report I see was filed September 23, 24. And with that, I'm going to turn this over to Ms. Turnbull.
Your Honor, I have met with all the parties. I had originally made a recommendation that Mr. Golahan's supervised visitation be expanded a few hours a week with his mother. He subsequently sent an email, which I have forwarded to the court in another interim review, which I believe everybody received. And my concern is Mr. Golahan's emotional liability and instability, his reactivity, and Parker's witnessing of that. I don't think, as long as Mr. Golahan is sober, that he would intentionally physically hurt her. But I do think I am concerned about his emotional state around her and what she may be exposed to there. I understand this information came into me late yesterday that he walked out of a supervised visitation last week after about 10 or 15 minutes when he became angry and left the visitation, and mom had to come pick up Parker early. So, you know, my conservative side of wanting to protect Parker from that is wanting to maybe limit that visitation so that she doesn't have to, she's not exposed to that until he gets some treatment. I understand, you know, this is going to be a decision that you need to make, and what sort of environment you want to put Parker in, and what kind of environment you're comfortable with her being in. But I do have concerns about his emotional state right now. And So.
Ms. Demeter?
Thank you, Your Honor. Yes, we share the same concerns as the guardian ad litem. Those have been the concerns that we have put forth throughout this entire case. It is concerning to see that it appears Mr. Golian is sort of devolving from where we even started as he becomes more frustrated with this process. Additionally, we're concerned now that he doesn't have counsel. There's nobody to rein him in. And as Ms. Turnbull's report pointed out, his mother, who this court has allowed against our objections to be a supervisor, doesn't see what her son is doing. Ms. Turnbull's report highlights that she doesn't see these issues, and she's one of the supervisors. And so the question is really, what is Parker dealing with here, and how much visitation should she be exposed to? Ms. Turnbull was also provided some messages with the school where they raised a concern that Parker, she's having issues at school after visits with her dad. I see Ms. Turnbull nodding her head. So we would ask there's no expansion, that the court determines whether or not it's appropriate to have some evaluations for Mr. Golian, and that we just don't expand. And in fact, we would prefer that the visits were limited and that they're only supervised by Miss Fillian's mother, grandmother, as they had been originally. But we understand the court is going to make whatever decision the court is going to make.
Mr. Golahan? Mr. Golahan, you'll need to unmute.
Yeah, sorry about that. I was having trouble. Yeah, so
Your
with the
camera
mall,
on. Mr. Golahan,
Yeah,
turn your
okay,
camera on.
yeah. Hold on a second. Okay, yeah, so with the mall visit, I left because Parker was upset. She's tired of going to the mall. And, I gave her a hug and said, I'm gonna leave because you're upset. And she just tired of being at the mall. So I wasn't angry. I just didn't want to make my daughter be somewhere she didn't want to be. She was tired of it. She didn't want to go to any of the stores. I didn't get angry. We sat and I tried to talk to her. Her mom told her she couldn't eat at all. And so we couldn't eat. It's 5 o'clock. That's a little frustrating for both of us. She wanted ice cream. And I told her no, and she got upset. And that's how that went. As far as the meetings with me and my mom, we've been going to the park, kids club. The last meeting went fine. Parker was really happy the last couple times. We went to the Saturday market. We walked around, did a bunch of stuff, played at the park. It went fine. And then, yeah, so I don't know where those statements are coming from. She's having troubles. She's probably having troubles from this whole thing. She was angry that I couldn't leave the mall Thursday. She's asking me to go to kids club. And I said, Parker, we can't leave. I'm sorry. And so she was frustrated that I couldn't leave. And as a 6-year-old, she can't really understand that. She's telling me, yeah, you can leave, Dad. And I'm like, I can't, but Saturday we can. So that's why we went to the kids club Saturday. And so as far as the evaluations, I think it's in my best interest to wait till my trial's coming up. I would appreciate it if I get my trial done and then come back to it, because I'm assuming all this is going to cost a lot of money. I'm not rich, so I'm working as much as I can. I'm missing work because of all this stuff. And then, so yeah, that's where I'm at right now. And as far as, with the visits, I would like to see my daughters, at least supervised visits. If anything, I think I need to see her and she needs to see me. And that's kind of where I sit right now. Yeah.
Anything further from anyone?
Well, I will support what Ms. Demeter said. I was forwarded some emails from the school counselor where Parker reported to the school counselor that she told Dad she didn't want to hold his hand, and Dad became upset, and this was upsetting to Parker.
No, that's not why she was.
Mr. Golahan, stop.
And Your Honor, I would just say that I understand none of this is in the record, but Grandma completely disagrees with Mr. Golahan's version of the events, and there was no restriction on them getting food.
So I did review the guardian ad litem's report. This has been set over to get the input from guardian ad litem in regard to what we needed to do. And I appreciate the report. And with that, I am going to follow the recommendations of Ms. Turnbull. And so that needs to be reduced to going through them. The supervised visitations will continue. the guardian ad litem has indicated that both grandmothers and any future supervisor sign and file the supervisor's oath, so that is appropriate. And when is your trial, Mr. Golahan?
It's November 19th.
Okay.
Right now.
So I am going to go ahead and order the hair and nail 5-panel test, ETG or SoberLink. If it, I'll leave it to you to talk to your criminal attorney in regard to that, whether you do it now or not. But if it does, then the weekends could be increased to 6 hours. And so in regard to a collateral substance abuse assessment, a collateral domestic violence assessment, a collateral psychosexual assessment with the parental risk component, the court will go ahead and order those. Understanding, again, you've got a pending criminal matter, and so I'm not necessarily going to, I'm not going to change anything at this point until I see what those evaluations end up being. But I understand if you don't want to do them right now because of the pending criminal matter.
Okay, yeah, I'd like to, if I can, object to that right now. Like I said, I'm innocent. I'm going to prove my innocence. And I haven't done anything to deserve that. And also it's in my best interest with my criminal case that I don't do another psychosexual evaluation. It's confidential. And with the guardian ad litem cooperating with the,
that's what
you want. Okay, well, I just want to tell you
okay, Mr. Golahan, you're not helping yourself by talking over me.
I didn't mean to, sorry. Apologize.
So those are ordered, but again, understanding they can be delayed until after Mr. Golahan resolves his criminal matter, so we don't put him in a bad spot as it relates to that charge. So Ms. Demeter, can you prepare an order that, bottom line, reflects the recommendations of the guardian ad litem?
Yes. Can I ask 2 clarifying questions, Your Honor?
Sure.
So I do understand that her report had said expanded. What I heard her say today is that she was no longer recommending that. Which recommendation are we going with?
So it's from the report that was from file 923.
Okay. And so, but those expansion is not until after the evals.
Correct.
Okay. Just wanted to make sure I understood that. And then my question on the restraining order, are we setting a review after his trial date and we would extend the restraints?
So why don't you go ahead and, Mr. Golahan, I apologize. You said November
19th.
19th.
Okay.
As
So
far as I'm concerned, yeah. Or as I know.
let's go ahead and set a review to November 26th. Is the week of the 19th your trial, you say?
The 19th, that's what they told me.
Okay.
Yeah,
Honor,
November 19th. So
I apologize, but I do have a trial on November 26th that starts at 9.
Okay, let's go to December 3 because I want to make sure that I don't want to set it too close and then find out the trial hasn't occurred.
Exactly. And if trial has not occurred, should we enter an agreed continuance or should we come back?
If you can do an agreed continuance, that's fine. But otherwise, just let's go ahead and look at it on December 3.
Certainly. Mr. Golahan, do you have an email that I may get?
yeah, it's my first and last name.
Thank you. I will be sending you documents to review for signature.
Okay.
Okay. All right. So that's it for today.
Thank you, Your Honor.
Thank you, Your Honor.
Do you want to do, well, hold on. Ms. Demeter, do you want to do a presentation of that order?
I think that would be a good idea, Your Honor.
Okay, let's go ahead and try to get that in place as soon as possible. So I'll just set it over 1 week. So Mr. Golahan, your next court date is going to be October 8 at 9. So Ms. Demeter is going to prepare an order. She'll send it to you. If you agree it reflects what I ruled, then you can sign off on it. If you don't, then we'll go forward on October 8 at 9. And
Okay.
then we have that other date of December 3, which is the review date of the restraining order.
Okay.
Okay?
Okay. Thank you.
All right. Thank you.
Thank you, Your Honor.
Alston v. Alston.
Yes, Your Honor, that matter's kind of ready. In that we originally filed this, it was originally heard on the 18th. It was moved to allow us to serve we served that same day. Mother was there on the 18th. It was moved to this date. On Friday at 11:40, my client was served. My office was not served. I'm highly doubtful that the state has been served, even though they are a party. They really waited to the last moment. It looks like from the court filing, it was also filed on Friday. I would still like to move forward because we've attempted to serve, and you'll notice from our certificate of service that mom's already moved. So because of that, I'd like to go forward today.
And I'm assuming you are?
Jessica Woodley.
Okay. So she is here in the courtroom. Go ahead.
Good morning, Your Honor. I'd like to apologize in advance. I'm really nervous.
Okay.
Good morning, Your Honor. I am the mother of 4 children. At present, Mariah has not yet graduated from high school. After careful consideration, I firmly believe that relocating from the city to a more rural environment is the best interest of my children, particularly Liam, who has been facing significant challenges in his current school setting. I've been offered a position at Asante Hospital in Grants Pass, Oregon, which will provide me with stable employment and the opportunity to further my education. I've also been accepted into Rogue River Community College, where I am guaranteed a spot in the nursing program due to fewer applicants. If you could please refer to Exhibit A and Exhibit B. Additionally, I have secured a housing voucher for Josephine County, which will facilitate the move should it be granted. The decision to relocate is largely driven by my concern for Liam's well-being. He currently attends Richfield School in Richfield, Washington, where he is struggling socially, academically, physically, and emotionally. He has been the victim of persistent bullying and frequently returns home in tears. His experiences at school have deeply affected him, and it is increasingly difficult to send him to an environment where he feels unaccepted, unheard, and unseen. The rural community in Oregon offers a safer environment, smaller class sizes, approximately 19 students per teacher, and more individualized attention for Liam, which I believe is critical to his success. His 504 plan will transfer seamlessly to Oregon, ensuring that his educational needs will continue to be met. Please refer to Exhibit C. I am confident that this fresh start, combined with smaller class sizes and a supportive environment, will significantly improve Liam's well-being and overall quality of life. Contrary to statements made by Mr. Alston in his declaration, pages 2 and 3, Liam does not spend 45% or 48.4% of his time with him. Liam has always resided with me and his siblings, attending school in Richfield Monday through Friday. Mr. Alston's role has been limited to every other weekend visitation. He has not attended any of Liam's medical appointments, as evidenced by documentation provided in Exhibit D. Furthermore, Mr. Alston has not been involved in any of Liam's school activities, as shown in Exhibit E. On page 4 of Mr. Alston's declaration, he references a CPS report, lines 16 through 21, in an attempt to discredit my parenting. However, Exhibit F demonstrates that these claims are false. I am asking the court to allow Liam to relocate with me and his siblings, who he has never lived apart from. Should the court determine that relocation is not in Liam's best interest, I'm fully committed to remaining in Washington with him. I am not seeking to alter the custody arrangement or interfere with the relationship between Liam and his father. Mr. Alston's involvement as an every other weekend parent would remain unchanged. I firmly believe that this move is in Liam's best interest. However, if the courts find otherwise, I will prioritize my son's well-being by remaining in Washington.
Thank you. Ms. Winkles?
Yes, Your Honor. First off, mom has already moved. You can see from the certificate of service that was filed that there is no furniture in that house. There are no people. Mom has moved. And in fact, the notification of move was given 1 week before the intended move. And you'll notice that as well.
I object to that, Your Honor. I have not completely fully removed. I have resided.
No, hold on.
Okay.
So your objections are legal objections if you're going to make them, but you'll have another chance to respond.
Okay.
Okay, go ahead, Ms. Winkles.
Yes. So mom essentially bypassed the statute. Now, what caused this? Well, mom and dad were co-parenting, and while mom is the primary parent on paper, dad essentially had 48% of the visitation. He had almost the entire summer. He had almost every single weekend. Dad was active in all of the extracurricular activities of the child and was present for almost every single game. The child does have ADHD. Dad was not present for any of those meetings because mom has moved the child 4 times over the course of the last few years. oftentimes not notifying the court, oftentimes not notifying dad. This makes it very difficult for dad to actually get in touch with the school because mom continually moves the child. This is due to mom's unstable housing and also unstable relationships. Mom is not being essentially genuine when she's talking about why she wants to move. The reason for the move is because mom has a 4-month relationship, and that person is attempting to move to Southern Oregon, Northern California, in order to enter the cannabis industry down there. This was a spur of the moment decision. Mom only let dad know a week ahead of time after dad had just gotten married. I think it's really important to look at the background of these two parties. Both of them had significant drug and alcohol issues. Both of them had criminal issues. Both of them got clean. My client has done very well for himself. He got clean. He opened his own business. He bought his own house. He got married. He had other children. Mom has struggled a little bit more. Mom has several children from other relationships that she has sole custody of. One of those actually wrote a declaration in this case, Mariah, who's just turned, I believe, 18, suddenly writes a declaration about my client handing people marijuana. Well, my client doesn't do drugs. My client has been great at maintaining his lifestyle. He is not following anybody in the cannabis industry. He's not handing 13-year-olds joints. I think you can see from the exhibits that have been delivered to your honor, some of them are more concerning than others. We have a CPS result from CPS from 2013. Clearly, they both identified that, they both dealt with the issues there, and they moved on from that. My client has other children. There are no CPS findings. There are no CPS considerations. There's nothing of that sort. We then have an email that is a little strange in the amount that's deleted from it and the highlights and the lowlights of the toner. It makes it look a bit strange, a bit faulty, a bit fake, to be honest. Then we have the mom stating things as, I got into this university. Well, mom didn't get in because it's open enrollment essentially, and your honor, my client has submitted those things. Anybody can get into this. It's a community college, much like LCC. If you apply, you get in. Mom then says, I have this job as a CNA. Mom had a job as a CNA here. Mom was working at Vancouver, was making very good money. Child was going to school in Ridgefield, was on a program due to ADHD. There is absolutely nothing in the record, minus mom's self-serving declaration that said, not even in a declaration, that says that the child was bullied, that the child was struggling, anything like that. What is true is that mom has removed this child from different schools 4 times in the last few years, causing the child to have to start over in an educational program over and over and over again. This lack of stability is causing the child's educational deficit. This is clear that when a child has to start somewhere else new every single time, they have to essentially learn everything those children know in that school to catch up. And then they have to go forward from there. Unfortunately, Liam is never able to do this because Liam keeps getting moved. As we all know, Ridgefield is one of the best schools in the entire state. It has one of the highest literacy rates. It has some of the lowest class sizes of all of Washington. It scores 91%, according to all graduation rates in the state median. Then we look at where the child's been placed, Grants Pass. Grants Pass has an incredibly low literacy rate. Grants Pass has high issues with crime. In fact, Grants Pass has 86% more crime than the rest of the state of Oregon. Most likely, this is because it is a high cultivation area of the cannabis industry. It's right there in that whole green zone, and likely there's probably a lot of crime in that. There is nothing in this move, and that's what we really have to look at. We look at the factors of, will this benefit mom? Will this benefit the child? If we look at these factors, there's absolutely no way it will benefit either of them. Number one, all of mom's family lives in Cowlitz County or Clark County. All of dad's family lives in Cowlitz County or Clark County. The child's support, stability, the child knows all of his family, knows his extended relations, knows his cousins, spends time with all of them. They're all here. Everybody that provides this child stability is located in this community. There's been no agreements of the parties. Mom came out of this out of left field, essentially 1 week before it happened. The fact is dad was becoming very, very central in this child's life. Has been for the last few years. Dad has taken a much more central role. And this is where we get the 48%. While mom may be on paper as having primary custody, the fact is this child was with my client the entire summer. Are there residential limitations for either of them? They both have substance use problems on their findings. They both have CPS reports on their findings. Nothing recent. Good faith. Is this good faith? Absolutely, it is not good faith. Dad tells mom he's getting married. Then suddenly mom says, well, I'm moving. I want a big life event as well. So mom is moving, chasing after a boyfriend of 4 months in the cannabis industry, uproots her family with no place to live. She gets a housing voucher from Josephine County. I think that says it all. She gets a voucher. She doesn't have a place to live yet. Getting the voucher from Section 8 does not mean you're finding a landlord that accepts Section 8. Those things are very, very different. Mom has absolutely no place to live. At the moment, mom has moved everybody into the house of a friend. That means all 4 of her kids, mom and the boyfriend, all living in the house of a friend, essentially living in the living room. This is not assisting and not being desirable for Liam's stability. Again, she's already moved 4 times. Without following any of the court's recommendations, the child keeps getting uprooted. Different schools, different extracurricular activities. Nothing about this is helpful to the child or mom. Mom's not making any more money. Mom is not going to go to this fancy school that she can't get here. Same idea. LCC offers the same program. And more importantly, LCC is in state, which means mom is a Washington resident. Why she's choosing to go to a community college out of state that's going to cost her significantly more is anybody's guess. If we look at the quality of life and the resources, again, everybody is in this area. This is a rural area, but it also has access to things that a child with ADHD needs, such as doctors. It also has behavioral therapists, occupational therapists, things of that nature. Whereas Grants Pass, frankly, doesn't have access to nearly the same amount of support and the same amount of educational opportunities. The other thing is the financial instability. Right now, mom is moving to an area where there's nobody to be there. They're living in a living room. In this area, she's got her family and friends to do babysitting. She can borrow money from family and friends when things get tight. The financial instability of having Section 8 vouchers, possibly having a job, the same amount that she was earning before. All of this is not in Liam's best interest. We're hoping. It's essentially them playing the lottery in hopes that they're going to kind of strike it rich, or, we're going to hit gold. But that is not what you do to an 11-year-old child. The fact is that this child needs what dad has been providing, which is stability. Mom moved without the court's approval. She's not in a program that would stop her from being able to change. If Your Honor stated today that Your Honor was denying the move, mom would come right back to where she was, probably into the same house. Child would probably go right back into school, only having missed a couple of weeks at Ridgefield. They'd probably go right back into their family. Mom would go right back into her job. Nothing would change. If Your Honor approves this move, she's essentially cut my client off. She's made it so nobody is watching this child in school. She's put them in a crime area that's 86% worse. And frankly, allowing mom to chase a guy who's been engaged 3 times in the last 24 months and to going and finding his marijuana dreams. So, Your Honor, we'd ask that you deny the move, that you force mom to move back. If mom doesn't want to change the parenting plan, that's fair enough. But that mom comes back to this county, and next time she moves, that Your Honor puts her on notice that she has to do the notification procedure correctly.
Hold on. Looney, anything you wanted to add?
No, Your Honor.
All right. This is your time for rebuttal.
Your Honor, I feel I have provided evidence to show you that Mr. Olson is being untrue in his signed declaration and has had the same ability to provide you with the same evidence, but has chose not to try to deceive you and to try to paint me as a bad parent. When in fact, I have been our son's primary parent his entire life. Moving, Mr. Olson has also moved 3 times in the last 7 years. As the economy goes up and down, individuals have to move, showing that Mr. Olson has had to move as well. My CNA license shows why it got pulled in the CPS case. However, I was able to get it back and I can continue my education now. The drug use I would like to address, it is in the current parent plan. If Mr. Olson was concerned, then why hasn't he given me a UA? Same for me, I have no concerns as him using any illegal drugs or substances. Richfield School, if your honor grants the move to Grants Pass, Oregon, Liam won't attend Richfield, nor if Liam moved to his dad's, he would not attend Richfield schools because his dad nor his wife, also my biological sister, would transport our son to Richfield. Mr. Olson is asking for Liam to reside in Longview with him, but also attend school in a different county. As far as Mr. Olson's and my sister's marriage, they have been together for 11 years. I've been well aware of their wedding. I even helped plan their wedding with my sister. As far as my significant other and I, we have been together for over a year. He has no criminal background. If the courts would like a background check, I would be happy to provide one. If Mr. Olson was concerned about my significant other, he should have expressed it to myself, or my sister, his wife, could have expressed it to myself as well. We were close until I disclosed my plans on relocating. I would also like to reiterate to your honor that should the court determine that the relocation is not in Liam's best interest, I'm fully committed to remaining in Washington with Liam. I am not seeking to alter the custody arrangement.
So I did review the files and record, and based on that, the court does find there is a substantial change of circumstances by the statements as a whole. And that's done in reference to what Ms. Winkles has said in regard to her client, as well as what's been said by the mother. As I said, the change is one brought on by either the mother's move to Oregon or by the alleged statements of the father. He has the child a substantial amount of time. As to whether or not it is in the child's best interest to make the move is unclear, in part because there is not complete information from the mother without, the declarations were not objected to. So the court is going to deny the move at this time. It was not done appropriately. So the mother, if she chooses to move back, needs to move back within 2 weeks. Okay. My question to you is, if you do that, are you going to proceed forward on this action?
Probably not. Probably just keep the parenting plan as the same as it was before, if Mr. Alston agrees to that.
Okay. So with that, I'm denying the move. I am denying the movement forward on this, and so the matter is denied.
Thank you. And did Your Honor want me to get an order to you?
Yes, make sure to send it to mom and let her review. So basically, she'll put an order together, send it to you. If you agree it reflects what I ruled, then you can sign off on it. If you don't, then it can be set before me and we can go through it.
Okay. Do I need to reside in Clark County where I was, or
you need to be in the same school district as you were? And if you move, you got to go, even from where you're at now, you need to go through the appropriate process to so you're not in the same kind of situation again. Okay. All right.
Thank you.
Thank you, Your Honor.
All right. So we have Mr. Anagnostou. This is and is it Coda?
That's correct, Your Honor.
All right. Counsel Coda. And I don't know if we have anybody else present on this matter. I'm not seeing anyone. All right. This is a restraining order request. Counsel, go ahead.
Well, Your Honor, this is it's my understanding the court set this over to continue the restraining order. We have trial set for the beginning of December now, and in the interim, Miss Acevedo had a dirty UA for fentanyl, and we've requested that she get into treatment. And anyway, that's where we're at. It's left at from the last hearing set over to this hearing. My understanding is to continue the restraining order because they have a time limit on them. And we've provided the court with a proposed restraining order, a continuing restraining order.
Coda?
So this is about the safety of Sam and Callie. My client is not a danger to her children, and she should have time with her children. As of today, she hasn't seen her kids for the last 52 days. And regardless of the soured relationship between Ms. Acevedo and the petitioner, it can't be healthy for children this young to be away from their mother for this long. And the final GAL report recommended that the children reside primarily with Ms. Acevedo. You can find this in the final GAL report, page 30. And unlike Mr. Crocker, who has a criminal and substance abuse history, Ms. Acevedo does not have a drug problem. And this has been confirmed on multiple occasions. The one and only time in which the UA came back positive was an isolated incident. And because of this, a second UA was performed 4 days later, after which came back negative. And she can't currently afford to take another UA or a hair follicle exam. However, she is willing to undergo these assessments at Mr. Crocker's expense, especially if it means getting to see her children.
Well, a brief response, Your Honor.
Go ahead.
Because they've brought up in the past, they've brought up CPS active investigations. That's just not true. There is no active investigation with regards to my client. The second thing is I don't see the guardian ad litem here.
I don't either. That's what I was just wondering about.
Miss Corey she's been provided all this information. And,
oh, there she is.
Oh, there she is.
Okay. Ms. Corey, do you have anything that you'd like to say?
Not particularly that hasn't already been said.
What are your thoughts in regard to mom having time here?
Well, I do know that mom was required in the past to do multiple UAs and complied with that, even though there were, I can't even remember how many there were. It was a substantial number. And this one did come up with some fentanyl in it. However, I don't see a pattern there of drug use for mom, and she is willing to do I think her attorney said an SUD evaluation regarding that. Frankly, I don't see a threat by mom. She resides with her father, and I have visited that home. It is a very nice home. And she should be seeing her children. They were, there was a accusation made by the father immediately after my report, that there was some abuse. Father took the children to, oddly, a emergency room in Vancouver rather than the emergency room here. And that accusation was eventually found unfounded by CPS. After that, I believe there was some injuries to the children in the father's care that was also investigated by CPS. I believe one involved a broken bone and another involved a child reaching up onto a hot stove and burning her fingers. I honestly don't see any threat here from the mother, and my recommendation at this point would be to reinstate some sort of visitation with mom.
Thank you. Ms. Cody, anything else from you?
I would just like to add that those injuries that Ms. Corey has referred to regarding Sam's broken leg and Callie's burnt fingers, these are injuries that occurred and there was no notice to Ms. Acevedo. So, and these were under the care of Mr. Crocker. So these injuries occurred, and the only reason that my client found out is because she's the primary contact in their medical records.
All right, I'll hear from you in just a minute, Mr. Anagnostou. Ms. Corey, the grandfather that mom lives with, do you feel he is okay and will follow rules in regard to supervising?
Yes, absolutely.
Okay. All right, Mr. Anagnostou.
Well, we disagree that Miss Acevedo lives here in Longview or in Cowles County. She was served and she has medical records out of a town just outside of Tacoma. And when we served her there, they acknowledged that she was living there. So she's conveniently saying she lives here with her father when that is to her benefit, and otherwise in all the documents and stuff she says she's living in just outside of Tacoma. And she had a drug treatment, and that's where the fentanyl showed up, was a drug treatment program out in the town up in the Tacoma area. With regards to the CPS, I have not heard about the burnt fingers. This is the first I've heard of that. My client, their son was playing on a trampoline, and he injured his leg, and he took him to emergency room and got that taken care of. CPS looked into it, and that case is closed. And I believe all cases are closed as to my client. He is not harming the children, but on occasion they get injured, and he supplied the pictures of when he gets the children back from Miss Acevedo with bruises and cuts and various other things. But I get the impression these are active children, and they fall down. Both parties are pointing fingers at each other, but I think it's something that happens to children from time to time. Anyway, it's our request, for the protection of the children, that there be limited contact to the mother until we can take this to trial and present all the evidence to the court.
Remind me, Mr. Anagnostou, is your client working?
He is not.
Okay.
He does get on occasion. He does work for around people's homes, but it's just very minimal. So he's if your question is, he's home with the children 90%.
Okay. And Ms. Cota, is your client working?
No, my client is currently unemployed. That's why she can't afford to do the UAs.
So here's what I'm going to do. We have until December for trial. Hopefully it goes forward in December because I believe it was stricken or bumped. But what I'm going to do is I'm going to go ahead and quite frankly, the court has concerns as to both parents and really where the children are at within each of their care. At this time, the children will remain with the dad and will have visitations with the mother, supervised visitations by the grandfather in the grandfather's home. And that will be on Saturdays. I'll just go ahead and make it on Saturdays. It'll be every Saturday. We don't have that much length of time from noon to 6 p.m. And so that's where dad needs to take the children, take them and pick them up. Or if there's a third party, Mr. Anagnostou, that might be the better route, is have somebody else that take the children. So we don't have a run-in between mom and dad.
Right.
And then every Saturday from noon to 6. I don't think there's any visitation right now, correct?
No, there's not.
Okay. Every Saturday from noon to 6. And then on Wednesdays from, let's see, what time do the kids get out of school?
Your Honor, my dad is unavailable on Wednesdays. He doesn't return home from work until 7 p.m. that evening. So Tuesday through Friday, he's not available.
Okay,
if we can do the visitation on Monday.
Stop. Ms. Cota, I'm trying to figure out a time for video conference.
Okay. So that means that there will not be a supervisor required?
Correct.
Is that what you're saying?
On the video conference, I wouldn't. No, just on this Saturday.
Okay.
So I'm trying to figure out the best date. If you want me to have your client address available dates at that point.
I think that would be more efficient.
Okay. All right. So Ms. Acevedo, because you don't work, I was just going to make it on Wednesdays at 5 o'clock for an hour to have video conferencing.
I appreciate that very much, Your Honor. But due to their young age, the children get very, very upset when we video chat. They want me to see them.
Okay.
They want
I'll just stop you at that. If you don't want to do it, that's up to you. You can
I
add.
think it's not good for their emotional and mental health.
Okay. Doesn't sound like your client wants that, so we'll just stick with the Saturdays from noon to 6. All right. So, Mr. Anagnostou, if you can put together an order, please, and I'll put it on presentation on October 8th.
October 8th
Just a second
presentation.
here.
Okay, very good.
All right.
Your Honor, Sherry Ewald, guardian ad litem.
Thank you. All right, with that, I believe this is on for a request to adopt the recommendations of the guardian ad litem. If you want to go ahead.
Me, Your Honor?
Yes.
Okay.
It's your request.
First, I wanted to apologize for how I've been mishandling my paperwork. I am currently trying to learn how to navigate the legal system, and I've spent countless hours in the courtroom with my 2-year-old trying to make sure things are filed properly. I would also like to talk about the TikTok videos that Mr. Sandana has referenced. The videos he cites with the Nicki Minaj song, which include the lyrics, "I just fell in love with a gangster," is simply a part of a popular trend, and gesturing of the flipping of the bird in the video was not directed at anyone in particular. It is important to note that Ms. Goebel herself has posted similar photos of her flipping the bird with captions like, "I guess I win again," after court. I have multiple photos and videos of me doing this directed at nobody specifically. The second video, I also used a viral sound that thousands of people have used, and I titled it, "When Your Ex Finally Pushed Your 6'4" fully reformed ex-convict to his limit." It was to try to make light of an incident that had already happened in the past where Mr. Sandana, when I showed up to Mr. Sandana's house to drop off things for my kids, at Mr. Sandana's home, a visit that he was well aware of. When I arrived, he refused to let the children come out to meet me, which forced me to approach his home. When he answered the door, he was visibly armed and told me that I could not speak to the children while having confiscated their phone.
Object at this point as this exceeds the scope of the declarations.
So, Ms. Swindell, you can only argue what's in the documents that you have filed.
This is the very first page of my document.
Yeah. Ms. McLean, do we have a child present?
I'm sorry. Yeah, my 2-year-old. I am waiting for my fiance to get home from lunch break to help me. She's just playing in the other room.
Okay. As long as it's in your declaration, go ahead.
Yeah. When I was there, I expressed my concerns then at the time for parental alienation, as he had taken my children's phone and would not let me speak to them and would not let them come outside to get the stuff that they had requested. Mr. Sandana has exaggerated this situation, falsely claiming that my partner, Mr. Musso, showed up to threaten them and him and his girlfriend, Ms. Goebel. We went to court for that because he tried to file a restraining order, which was dropped. And Mr. Sandana has continuously claimed that my partner, Mr. Musso, is a white supremacist based solely on his appearance. Mr. Musso, while physically imposing, is not and has never been affiliated with any STGs. It is important to note that when he went to court to try to file a restraining order, he was not trying to change the parenting plan at any time. It was not until I filed to change the parenting plan because my oldest, my 15-year-old son, asked to live with me full time because him and his father had been arguing. After my children and Mr. Sandana moved in with Ms. Goebel, she quickly became involved in our children's lives, including coaching our daughter's soccer team. While I appreciated her involvement, I was hurt by how clingy she became with our children, particularly our youngest, Jada. Despite my best efforts to build a cordial friendship with Ms. Goebel, reaching out to express my appreciation, she often responded dismissively, rudely, or not at all. Though Ms. Goebel has portrayed herself as a mediator in this situation, she has been far from impartial. She has made hurtful comments to my partner, such as she has a better relationship with my daughter, Jada, than I do. She has exaggerated incidents, including a remark I made about her appearance in a private text message to Mr. Sandana, and has said that I loudly proclaimed it in a soccer game, which was extremely untrue. I want to address the statements made by my father, Matthew Swindell. I've never accused my father of inappropriate actions towards me. However, I have accused him of inappropriate behavior towards my cousins, including one of which who lived in his home from the age of 7 years old. Additionally, the home I built next to my father's property was not a choice, but rather a condition imposed by my uncle Scott Swindell, who controlled my mother's trust, controlled the trust left to me by my mother. He restricted my ability to purchase any other property, forcing me to build next to my father, the property that him and my father both owned. The truth is, I never had a meaningful relationship with my father or his family during the time I lived there. I did ask to move in with my father in 2012, but this was only after Mr. Sindana's mother physically assaulted me in front of our 3 children. We were living in her house. It was a very rundown house, and we were all 5 of us living in 1 bedroom. Mr. Sindana was not working at this time. After a month of living with my dad, I was able to get a job and a home for me and my family. I have very vivid memories of my father verbally assaulting and degrading me from ages 11 to 17, but I have never said I have memories of him touching me inappropriately. However, I lived in his home when one of the inappropriate actions towards my cousin occurred, which eventually led to her running away as a senior in high school. Throughout this case, I have been open about my mental health struggles, and I have actively been working with my therapist, prescriber to manage my PTSD, depression, and anxiety. While I have had 1 suicide attempt in my past, Mr. Sindana consistently exaggerates this, falsely claiming that I have had multiple attempts. He also manipulates my marijuana use, even accusing me of using hard drugs earlier in this case. Contrary to what Mr. Sindana claims, I have never expressed a desire to smoke marijuana with my children. His accusations are baseless, and I believe it is fabricated to further his smear campaign. My primary concern has always been the well-being of my children. I have attempted to raise important issues with their doctors, such as Jackson's recent development of tics. Despite this, Mr. Sindana failed to refill Jackson's medication after March 19th, 2024, when he was placed in his care. Without consulting his doctor, while stopping the medication may ultimately have been Jackson's choice, the sudden discontinuation could have serious side effects, and I believe that these decisions should be made with medical guidance. Your Honor, my concern in this case has always been my children's mental health and well-being. I feel the smear campaign orchestrated by Mr. Sindana, Ms. Goebel, my father, and Kristen Otto is designed to discredit me as a mother. While I am not perfect, I have been doing everything in my power to heal from a lifetime of abuse and trauma. I'm working closely with my healthcare providers to manage my mental health, and I will continue to fight for what is in my children's best interest. The GAL report reflects the best interest of my children, as it should. However, it is clear that anybody that doesn't side with Mr. Sindana becomes a target for his attacks. Further demonstrating the manipulative tactics, despite everything, I will never stop fighting for my children, and I trust the court will see the truth behind these accusations. I also want to bring up the fact that our court hearings have been all recorded and posted on YouTube, and then a TikTok account was made in August to also post all of those. They have reached over 120,000 views. I talked to the court. I went to the court the day I found out, and I asked them if these were posted on YouTube, if anybody has any way to access them. They said no, that the only way anybody could access them was if they were logging into our Zoom courts and recording them. I feel like this is part of another part of his smear campaign, that he's orchestrated other people to come into our court hearings and record them and then post them to further his agenda. I'm hoping that the court takes what the GAL has to say seriously. It makes several claims that Mr. Sindana is very controlling, that his children have claimed that he is very controlling and make him feel uncomfortable, that he stands very closely to them to monitor any conversations that I have with the children. I believe that this is very unhealthy for my children, and it needs to be addressed.
Thank you. Ms. McLean?
Thank you very much, Your Honor. So first off, obviously, I am concerned about the declaration submitted by Ms. Swindell that don't comply with the local court rules, and the additional declarations that are beyond the page limits and the pagination of that. So I'll just point that out to the court and leave that to the court's determination as to what you consider as it relates to those issues. And as you commented earlier on this docket, the guardian ad litem report is simply that. It's a report, and it's totally up to the court to ferret out the evidence and make a determination on what the court believes is in the children's best interests. In regards to the facts that are outlined in the guardian ad litem report, we've submitted my client's reply declaration as well as 2 witness reply declarations outlining the irregularities and the concerns as it relates to the inaccurate information or factors that were submitted as part of the guardian ad litem's report. And again, ultimately, it is the court that is to consider the facts and the information, weigh the credibility of the parties, and ultimately make the determination on what you believe is in the children's best interests. I would submit that given the substantial differences in the information that we've provided in the declarations, that this is something that a trial court needs to hear. I believe that I've noted it up for mandatory settlement conference assignment. We haven't had a mandatory settlement conference yet, so we'll participate in that process. And if we're unable to reach an agreement, then ultimately it's a matter that needs to go to trial. I would note that, first off, there has been absolutely no substantial change in circumstances in the factual scenario of this case since the temporary orders were entered. And Ms. Swindell has now been removed from that joint custody that they were previously exercising since early this year. And because of her own behaviors, totally within her control, her own behaviors have resulted in her not having any contact with the children since May of this year. So she's been 5 months without contact with the children. And the court has ordered her in 2 separate orders. One, your contempt order that was entered on July 2nd, and as well as the order that you entered on September 17th. Both of those orders required Ms. Swindell to participate in a new collateralized substance abuse evaluation within 30 days. We are 3 months removed since the July contempt order was entered, and she has provided absolutely no proof of any efforts to stop smoking marijuana, no proof that she has a clean hair follicle in UA, no proof of a collateralized evaluation. So right out of the get-go, we have absolutely no verifiable information. One, that her prescribing physician or psychiatrist has approved her use of marijuana to treat her PTSD, depression, and anxiety, as she suggests. Those are significant concerns, particularly in light of her past behavior as a result of her depression with a suicide attempt with the children in the vicinity. It's also concerning when you take a look at her reactive nature during the pendency of this case. She certainly cannot control her reactions to benign emails of information that are provided to her. She has to react and engage in conflict. And as the court knows, there's multiple studies about how dangerous conflict is to children. She attempts to switch it up and suggest that Mr. Sandana is the one, he and his girlfriend are the ones that are engaged in conflict, but you have no documentary evidence or factual evidence to support those baseless claims. So at this juncture, you have a mother who, again, holds all of the answers to her concerns, and that is she needs to get clean. She needs to do those evaluations that the court ordered and follow through with her mental health. And she herself identified that her mental health is a concern and that she's done all of these things, and yet we have no verification that she is stable. In addition, it's concerning that her marijuana use is somewhat normalized in the guardian ad litem report and recommendations. The recommendation from the guardian ad litem was, well, maybe she needs to do a substance abuse evaluation. The court's already ordered that, and she's not complied. We have concerns that as it relates to her own documentation that we filed from her mental health provider, where Ms. Swindell identified that she was an habitual user and she was engaging in excessive cannabis use, and that was also adopted by her counselor. That was one of the findings. That's from November of 2023. The Columbia Wellness Record acknowledges that there was an increased risk due to alcohol and substance abuse. Couple that with the CPS records, where Jackson, the oldest child, is reporting to CPS that he's aware of mom using, he's observed mom using, he's observed her using a vape pen and a bong. And again, we're talking about an impressionable child who was 14 at the time, now 15. Couple that again with the fact that one, we are here because of her behaviors, and her immediate concern was addressing those TikTok videos. She, the TikTok videos, as well as the court hearings that have been streamed. We have absolutely no control, and I don't know what control the court has over somebody recording those videos. We're aware that we're not allowed to do that. My client tells you he has not done that. My client has provided you documentation where he has reached out to the one of the posters, one of the individuals who post, or the identifier who posts those videos, and there's been absolutely no response. My client, his girlfriend, Ms. Swindell's father, have not video recorded those. And you'll even see in my client's, I think it's Exhibit C, is this is attached to his declaration that we filed on September 17th. Oh, I'm sorry, not that one. We filed it on September 26th, where Ms. Swindell engages in communications about at least her perspective of this. And you can see where there's multiple other hearings from different jurisdictions that are populated under these sites.
Let me just stop you for a minute. In regard to the videos, they're being recorded by somebody who gets in either under a false name or something. So they are not to be recorded, but it happens. There's nothing we can do about it. So let's move on.
Okay. But simply to point out that my client has not done that.
Yeah, I understand.
Too is concerned about the children seeing that, and go back to Ms. Swindell's TikTok videos that she herself has posted, and she has hashtag divorce and hashtag co-parenting struggles. Those are things that her children can see, and she's the one posting those, and yet she's complaining about these hearings being potentially available to the children. The children can search her name and see her TikTok videos. Extremely unhealthy, particularly following these hearings. My client tells you, and his significant other tells you about the concerns where, first off, Ms. Goebel was asked to be essentially a mediator between the parents, the suggestion by the GAL about her being the mediator, and yet her advising Ms. Ewald about the significant other of Ms. Swindell, Mr. Musso, one, his felony history involving very dangerous assaultive convictions, and two, the ongoing threats of him essentially being the heavy to enforce Ms. Swindell's wishes. That type of optic is not good, particularly when you have an individual such as Ms. Swindell who's invested in drama and conflict. The declarations outline significant concerns about the disruptions during some of the interviews, the nature of some of the conversations. Even Ms. Swindell in her argument says, you know, I've never made allegations against my father. Look at the Guardian Ad Litem report. The Guardian Ad Litem report in and of itself acknowledges that the father, the grandfather, maternal grandfather, should not be present because of the, and this is number 12 on page 24, due to mom's statements regarding her childhood abuse by maternal grandfather. Maternal grandfather should not attend any event or function. That's the Guardian Ad Litem's conclusion based on Ms. Swindell's own statements to her that she was abused as a child. She says something completely different today. So
objection. I believe I said I was not sexually abused by my husband or by my father.
Okay. All right, wrap it up, Ms. McLean.
Okay. So our position is that the court should not adopt the recommendations. Ms. Swindell has not complied with the court orders. She's continuing to use. We have concerns that she continues to not be mentally healthy, and we believe that the court should deny the request adopt my proposed order that I've submitted to the court and award my client $1,500 in attorney's fees for having to respond to all of this.
Steve-Ald, anything you wanted to add?
Yes, Your Honor, thank you. I understand the party's not loving the report all the time, but I did have the opportunity, a unique opportunity that I've been able to speak to all parties, including the references and the collateral. I've been able to see the substance abuse evaluation that was done. I've reviewed medical records. I stand by my report. I'm very comfortable with it. These children are older, and my job was to be their voice, and their voice is that they would want to be with their mom and dad. Both mom and dad are good parents. I didn't say they weren't. And I firmly believe that that needs to take place. I did review my recommendations. I don't see anywhere where it stated that I felt mom needed to have another substance abuse evaluation. Noelle, Ms. McLean had brought that up. I don't see it in the recommendations. I didn't review the full report right now, but I do stand by this report. I'm very comfortable with my findings.
Thank you. Ms. Swindell, keep it short. I still have other cases. You have a chance at rebuttal.
Yes, ma'am. Thank you. I would like to say that I did do a substance eval. It was April 23rd, 2024. I had given Ms. Noelle the copy of the substance abuse evaluation that said no treatment is recommended at this time and that I have no substance. Mr. Sindana did not reach out. They claimed that I gave them the wrong number, which I followed up and corrected my typo. They're trying to say now that I did not give them the right number, but I did. And he has called the substance abuse lady, Michelle Buckles. He's called and given her collateral information that did not change anything, and he's unhappy with that situation. So he wants me to complete a whole nother one. I don't think that that's fair. I think that he is, anytime anyone doesn't side with him, he's going to want something new. And I think that this is an abuse of power, and abuse of money, quite frankly. And I just hope that you see what's in the best interest of my children. I'm, like the GAL said, we're not bad parents. We have conflict between us. And I'm hoping that that conflict can be resolved and we can move on with our lives. This is absolutely out of hand.
So I did review the files and record, the statements that have been filed, and the court recognizes the guardian ad litem spent a lot of time investigating this matter and appreciates the work. And again, as I say, guardian ad litem reports are a recommendation. Clearly, there are disputes as to what's been said, which is not necessarily unusual either. Clearly, the parties see things differently, and there's only one way to get this matter resolved. And so the court is not going to be changing anything at this time. And the matter needs to get noted for trial. I think you said there's an MSC.
I believe that I noted it up for an MSC. I apologize. I should have looked at that date.
When is it? November 18th.
Yes.
Okay. So Ms. Swindell, do you know what MSC is?
Kind of.
Okay. So it's called MSC for Mandatory Settlement Conference. And it's an opportunity to meet with a judge. That judge then recuses himself after hearing in the MSC. But basically, the attempt is to see whether or not the parties can reach an agreement rather than proceed to trial. So that's the idea of an MSC, is to see if a settlement can be reached between the parties.
And there is more information available on the court's website that she can access, and we can forward that link to her if she needs it.
Okay. So why don't you go ahead and just do that, Ms. McLean, if you would. And so that will be happening. But bottom line, the matter needs to get set for trial. It needs to be heard as a whole as to what needs to occur. As to the request for attorney's fees, the court understands why that request may be made, but I think Ms. Swindell properly brought the matter before the court, and the court doesn't find any fault in that, just not agreeing at this time to make changes. So
do you want to do a presentation, or do you want to make adjustments to the order that I did provide to you? Or
so what I would suggest is just get me a clean order.
Okay.
And if you can't come up with a signature by both parties, then note it on.
Okay, I can do that. Thank you.
Yeah. All right, counsel, go ahead.
Yes, good morning, Your Honor. We're here on a temporary family law order, particular protection, a parenting plan and child support today. It doesn't appear, and Mr. Jones can correct me, that the other party has filed a parenting plan, so we're asking the court to adopt our parenting plan, which asks for 3 telephone visits per week. We're also asking the court to adopt our child support worksheets. That's what we're asking.
Anything else?
Not at the moment, Your Honor. I just want to see.
Mr. Jones?
Yeah, Your Honor. So this case, I'm not sure if you remember, but we started out hot and heavy with protective order. There was an incident with the party's oldest child, who's now over 18. It involved alcohol with my client. My client acknowledged his alcohol problem. He did a 45-day inpatient treatment plan back from May to July of this year. He is now in active recovery. He's going to AA meetings and doing what he needs to do on his end to maintain that sobriety. The unfortunate thing in all this is that he lost his higher paying job. He was a project manager for a construction company where he was kind of the client facing project manager, meaning he would go and meet with folks. If he was building a hotel in Texas, he'd have to meet with the owners and work on how to get the project done. He's lost that job because you can't have a felony and assault for conviction and still be a client-facing project manager. So now he's struggling to find work as a normal construction contractor. He is on unemployment. He's making $919 a week, approximately $3,600 per month. So we're asking the child support be set at that income amount. It'd be inappropriate to use his former income because he has lost his job. He's no longer earning that income. And we now have proof of what his actual income is, and that's the unemployment benefits. My client would like to expand on parenting time. We understand that the kids are now in Georgia. He would like to continue FaceTimes or Zoom calls with the children, but also have the opportunity to go and visit them when he gets approval from his probation officer in the Washington case. He admits that the alcohol played a factor in how his relationship worked with his children and his wife. He's remedied that situation with the inpatient treatment and continue to go to Alcoholics Anonymous, etc. So he'd like a path moving forward to be able to rekindle his relationship with his children in person moving forward. I think that's all we have to worry about today.
Yes, Your Honor, if I may respond. Yes, Your Honor, we're asking that the Zoom calls continue. We obviously appreciate the treatment, but there just hasn't been, again, simply enough time to for the opposing party to prove himself. And so we're asking for more time to do that, and expanding upon the parenting time right now is really not in the best interest of the child, given the information in the pleadings. I won't rehash that, but again, we're asking that the parenting time be limited to 3 phone visits per week.
All right, so in regard to the parenting plan at this time, I am just going to do the phone visits. So essentially adopt the mother's proposed plan. At this time, I think it's most appropriate. I think as time goes on, that it makes sense to, take another look at it, see how the phone visits are going. And then, as I said, the court can consider it later. And how long have they been back east?
Ms. DeGrice, you can.
Since June 20th.
Thank you.
Okay. So I guess what I'm thinking is if they're going fine, come December, that would probably be a good time to bring it back, and when the holidays are going on, and see whether or not that could be a potential time when the children, I don't know what their schedules are come holidays, but maybe look at it at that time. But at least for now, we'll just do the video conferencing and bring it back. Child support, that one's difficult in the sense of all of us, I see this so often where all of a sudden somebody's out of work and not making the same income they made And so at this time, the court is going to set the father's income at the $85.20 per month net. And in regard to the mother's income, $29.68 per month net. As far as the other requests, each is responsible for their own future debts. Do not change insurance, etc. That's granted. And in regard to the wife's request for the husband to pay $5,000 in attorney's fees, I'm going to go ahead and reserve on that, understanding that there is potentially a shortage of funds at this time, but the court will reconsider it at a later time to come back on that. And then I don't know what, I'm assuming there's a restraining order in place at this time. Yeah.
Yes, sir.
Yeah.
Okay. Anything further?
Not that I can think of. Thank you, Your Honor.
Okay. Do you want to, if you can't come up with an agreed order, just note it up.
Okay, great.
All right. Thank you.
Thank you.
Amy Powers here for Miss Esty, and I believe Miss Esty is present on Zoom as well.
Okay. And Daniel Esty is present here in the courtroom. So with that, Ms. Powers.
Thank you, Your Honor. We're here today on my client's motion for temporary orders, and I'm going to start with the easy issues that are before the court today. The first one is that we are requesting the court appoint a guardian ad litem, and we think that that's especially important given the mental health concerns that we have about Mr. Esty, and that he has also raised some concerns about my client. My reading of Mr. Esty's response is that he is in agreement with appointment of a GAL. So that's our first request. Our second request is that each party be able to continue using their own vehicles. I don't think that's contested either. My client drives a 2019 Subaru Ascent. She would continue to use that. The father drives a 2008 Scion and can also possess the motorcycle. The last issue that I don't think is contested is that we're asking the court to divide the debts. We're asking that Miss Esty be responsible for the credit cards that are just in her name and the car loan for the Subaru which she drives. We're asking that Mr. Esty be responsible for the credit cards and loan of credit just in his name, the car loan for the motorcycle, and also the Red Canoe joint line of credit. My client has already paid off half of the balance of the joint line of credit, so we're asking that he just continue making the payments on that. And then we're asking that each party be responsible for half of the personal loan or that they took out from Miss Esty's mother, which was used to pay off credit cards. So those are the easy issues. The other two things we're asking the court to address is a temporary parenting plan. The parties in this case married in 2013, and they have one child together, Melody, who is age 9. The parties separated in March of 2024. Since their separation, Miss Esty has been the primary parent, and Mr. Esty has been having visitation approximately every other weekend. We are asking the court to make some 191 restrictions based on emotional impairment of Mr. Esty. We detail in my client's declaration that there's been some concerns about mental health problems. Mr. Esty was hospitalized in November 2023 for suicidal ideation and mental health concerns. Mr. Esty explains in his responsive pleadings that that was because a close friend of his had attempted suicide, and he was on the phone with this. What Mr. Esty does not mention in his declaration is that was his 17-year-old girlfriend. Mr. Esty is 34 years old and was involved with this teenage girl during the time that she attempted suicide. She ended up hospitalized.
Hold on, Ms. Powers.
I would like to make an objection to that. We were not having a relationship at that time. That did not happen until later.
Objections are legal objections.
Okay, I'm
so you'll have a chance to say
I apologize.
something. Okay, go ahead, Ms. Powers.
Thank you. So Mr. Esty and this 17-year-old both ended up hospitalized at the same time. Once this 17-year-old turned 18, the parties openly are dating, and this 18-year-old moved in with Mr. Esty this summer. This is really concerning to my client. Their child's only 9 years old, and this doesn't appear to be safe or healthy relationship modeling. Mr. Esty resides in a one-bedroom apartment. It's unclear He provides some information that Elizabeth has her own space in the apartment. It's not really quite clear where that is or how that works out with Mr. Esty and the 18-year-old girlfriend in the home. For these reasons, we're asking that the court limit Mr. Esty's visitation so that it's supervised by his family. We're asking that the court continue Ms. Esty as the primary parent at this period of time. That's what she has done historically. This child has been homeschooled, and Ms. Esty has done the bulk of the homeschooling. Our proposed parenting plan is that Mr. Esty can have every other weekend. Under Mr. Esty's work schedule, he gets 2 consecutive days off per week. That's often not on the weekend. The last schedule we were aware of, he had every Thursday and Friday off, so we would request that that be his visitation. And that the child go to him Wednesday evenings. The parties had been exchanging her at 9:45 p.m. Based on the end of a church meeting, and then he could keep her till Fridays at 7 p.m. If Mr. Esty's work schedule has changed and his 2 days off have changed, then whatever his 2 days off, we would ask that that be his visitation every other week. We're asking that the child be exchanged at both parents' homes and that the picking up parent be the one to do the transportation. And so that's our request in terms of a parenting plan. We're also asking the court to enter a child support order. We have provided for the court that the mother works 25 hours per week as a barista at the hospital. She does not get tips at the hospital. Her monthly gross is $1,925 with a net of $1,706. The father works 28 hours a week, driving the city bus. He grosses around $3,000 per month and nets $2,575. I recognize that the number of hours they are working are less than what would generally be considered full-time, but it's my understanding that both parties have worked this number of hours for many years, that's been the pattern in their relationship, and for that reason, we left it at those actual hours. Mr. Esty mentions in his response declaration that he's no longer working 28 hours a week, that his hours have been reduced, and so he would like that taken into consideration. Since we've only put him at 28 hours a week, we would ask that he stay at 28 hours a week, and if his hours have been further reduced, we would say that we would ask the court to consider him underemployed. Based on those actual incomes of the parties, the transfer payment would be $527 a month, and we're asking that that begin in September. Thank you.
This is your opportunity to tell me what you'd like to tell me.
First off, there was that was an inaccurate statement about when our relationship started. Our relationship did not start until December 2nd, and that was sometime after the attempted suicide of the other party. I put myself through, I actually admitted myself to the ER because I just didn't know how to deal with the trauma that I just experienced, trying to convince someone not to do something like that, to stay alive, over and over again. And I was already dealing with some mental stuff before that. But I put myself through treatment in an inpatient facility where I then, after that, with my own money, I admitted myself into a partial hospitalization program for several weeks. And then after that, an intensive outpatient program, taking several months off work to deal with my mental health issues at the time. And then since then, I've continued to see a psychiatrist and a therapist and have medications for various things like ADHD and anxiety and depression, which I'm taking regularly. So I'm dealing with the mental health aspect of it. I've had several psychological evaluations this year because of my job as a CDL driver. I had to have one before I could go back to work because it's a safety sensitive job. And then I had to have another one before I can get my medical card for my CDL renewed for the same reasons. It's a safety sensitive job. They want to make sure you're okay. So I've already had psychological evaluations for those things. I've been at work since February 20 something, I believe. And during that time, there seems to be no issue with me taking care of my daughter at home or even taking her out to do things. That did not start to become an issue until after I moved out of the house. And that's when things kind of started taking a turn with how she felt about it. But that up until then, even when she mentions in her paperwork that my having ADHD and depression interfering with my parenting, and that's why she wants to put restrictions on me and have my visits supervised for now. I've lived with those my whole life. We've had our daughter for 9 years. It was never an issue before, just until recently after I moved out, like I said. I'm a little nervous.
Okay.
So there's never been any incidents with my daughter. There's never been any domestic violence, physical or mental abuse, verbal abuse, nothing like that. I've always taken care of her. We've both taken care of her. Elizabeth did more of the around the house things, but we had an equal share in taking care of our daughter. And as far as decision making goes, we both made the decisions together. She may have executed some of the things, like we made the decisions about her education together as a family. It was never done separately. She was never like in charge of that. We both did those things equally, but she would like set up the schooling and get things started, and we both would do the schooling. In fact, Melody was just at my house just this last week, and we did schooling on her school days. And every time she's with me, we do her schooling. The only time Beth did the brunt of the schooling is when I was having those mental health issues and I needed to take a step back, and then she took over most of the schooling at that time for a few months. But we've both been very involved in her life and very involved in taking care of her and providing for her needs, her food and her emotional needs and everything. So I'm not sure why she's trying to say that she's the one who's done most of that when we both worked as a team for years to take care of our daughter. And as far as her scheduling goes, in her paperwork, she wrote down that I had Melody Wednesday through Saturday morning, but clearly I have a schedule that she made, and I know you have a copy of it, I believe, where I have Melody Wednesday through Monday morning. And at first, she had her on Saturdays while I was at work because she did not want me using childcare. She didn't want a babysitter watching her. For some reason, when I was at work, it seemed to be an issue with her, even though she works 5 days a week and leaves Melody at home all the time with her grandmother. But she had an issue with me using a babysitter, even if I paid one. She would rather watch her herself, which was fine, and I conceded to that. But then at the end of July is when that changed, and I ended up keeping Melody every other week from Wednesday through Monday morning until Elizabeth got off work on Monday afternoon and then would come and pick her up. So that's what we've been doing since the very beginning of August, actually. And then as far as the living situation goes, I do have a 1-bedroom apartment, but it has got a pretty spacious living room, and we have a full room divider set up for my daughter. She has her own bedroom in that living room with a divider that goes all the way across, and she uses one part of it as a door to open and close. So she has complete privacy in there. She is able to come and go from there as she pleases. Whereas the living situation she's in with her mother, Elizabeth lives with her mother in a double wide trailer that has a double living room. And for the last, I believe, 5 years, we had been living there together in the living room, in one of the living rooms. And after a while, we walled part of the living room off and put a door up in the kitchen. But so they're still living in just half of a living room with no privacy between her or Melody. Melody can't go anywhere to get away. She has her own area in the room, but it's all open and visible. And as far as Melody has told me that she sleeps almost every single night in her mom's bed with her, which I don't really have an issue with. But it was an issue for, this isn't in the papers. This is just stuff we had talked about. But yeah, in my place, Melody has her own space, and we've decorated it. She's got a TV in there and everything like that. She's got a bed, place to store her clothing and toys, and we're continuing to improve the space. But I know a 1-bedroom may not be ideal, but neither of us have ideal living situations right now. And we're both just doing the best with what we can. And as I said earlier, there have been no issues with Melody. We've both taken care of her. I thought we were both doing a really good job with the co-parenting. I wanted her more. I want to have her, half and half. And that's what Elizabeth said that she wanted to work towards. So it kind of came as a blow when I got this paperwork, and she wanted to reduce it further to just 4 days a month and have it supervised and as far as the supervision goes, I'm not sure what their reasons are for that. If it's just me having mental issues, but as I stated earlier, there seemed to be no issues before while I was living at home, and this didn't start happening until after I moved out. So I'm not sure if I've touched on everything. I'm sorry. I haven't had very much time to prepare for this personally because I was trying to get a lawyer through my work's EAP, but they took several weeks to get back to me and tell me there's no lawyers in our area that they would go through. And so I don't have any counsel. I haven't spoken to anybody yet. So if I'm a little ignorant as to how things work or to anything that I was supposed to submit or talk about, I apologize.
I did read everything, just so you know.
Okay.
Okay. All right. Ms. Powers?
Thank you. Just briefly in reply, Your Honor, I want to be clear that the restrictions we're asking for are not because of Mr. Estie's ADHD diagnosis. We're asking for these restrictions because he's had mental health concerns. We don't know what mental health treatment he's had since the parties separated, but we do know that he's moved in this 18-year-old teenager who he's in a relationship with, who both her and him struggled with suicidal ideation less than a year ago. That's our biggest concern here. And that's what changed. The parties had been trying to work together. And in, I believe it was July or early August is when the girlfriend moved in with Mr. Estie. That's the big change here. We don't know a lot about this girlfriend. We know that there's this huge age gap. We know that there's been mental health concerns from both Mr. Estie and from this girlfriend. We know they're in a one-bedroom apartment. That's our biggest concern here. And then I would just point out in terms of what the parties have been doing, if you review the schedule that Mr. Estie submitted, his visitation has still been every other week. My client has allowed some optional additional time, but it was every other week. And we believe that our proposed parenting plan is closest to what the parties have been doing. Thank you.
Sorry.
So I have reviewed the files and records. So the first thing we're going to do is we are going to appoint a guardian ad litem. What are the next three names?
Sherry Ewald, Keith Lawrence, and Karen Lawrence, Your Honor.
I'm sorry, I could not hear those.
Sherry Ewald, Keith Lawrence, and then Karen Lawrence.
I will strike Miss Ewald.
Okay. All right, so you have an opportunity if you like to strike one of these. If you don't want them, there's either Keith Lawrence or Karen Lawrence.
I have no information about any of them. I have no
Okay.
idea.
So we'll go with Keith Lawrence. Is Keith Lawrence still on here by chance? Do we have Keith Lawrence on here? Do I have Karen Lawrence on here? Okay, well, the court does have concerns in regard to the mental health issue and understanding that you may have gone to treatment and done all the right things. The court just doesn't have the information that the court wants to see before doing something more than what's being proposed. So I am going to go ahead and adopt the mother's parenting plan at this time, again, noting the concerns regarding the mental health of the father, and the court finds that most appropriate at this time. The reason I was asking whether Keith Lawrence was still on here is I would like for him to do a quick turnaround. I just don't know if he can. Hopefully he can. And so I'm going to set this out 6 weeks to November 12th for Mr. Lawrence to do a report at that time and hopefully look at your mental health records and see where things are at. And we'll look at a possible update in regard to the parenting plan, depending on kind of what the outcome is. Do you know what a guardian ad litem is?
Yes.
Okay.
Is that, so you said November 12th is the.
So that'll be
court
another
date?
hearing,
Okay.
court hearing at 9 a.m. And so we'll appoint Keith Lawrence in regard to the payment based on the incomes of the parties. I'm going to make that county pay. As to child support, that made sense, Ms. Powers, as to what you proposed, that the parties have been working at the reduced hours for an extended period. So I'll just adopt your numbers as far as that part of it. And the child support will be set in accordance with the numbers indicated. personal property, each is to have use of the property in their possession, including the wife have the 2000, I think I got this right, 2008 Scion, and the husband the 2019 Subaru Ascent. Did I switch those?
Other way around.
Okay, I switched them. And then the motorcycle. So yeah, we'll switch them back. The 2019 to the wife and the 2008 Scion to the husband. Debts, the wife is to pay those credit cards just in her name, the Red Canoe Credit Union loan for the Subaru, or whichever vehicle. Yeah, she has the Subaru, and the husband is to pay those credit cards just in his name, the line of credit just in his name, the Red Canoe Credit Union loan for the motorcycle and the Red Canoe line of credit, and then each is to pay 1/2 the amount owed to the wife's, I believe it's mother, to pay off the credit cards. So that's pretty set out as far as what needs to happen. So what's going to happen is Ms. Powers will put together an order that reflects what I ruled today. And I'll go ahead and set a presentation on for October 8th with the basically she'll send you a copy of that order after she drafts it. If you agree that it reflects what I ordered, then you can just sign off on it and you don't need to be here on October 8th. Okay. If you disagree with it, then you need to be here and we'll address that. Meanwhile, in regard to contacting Keith Lawrence, his name and phone number should be on our Cowlitz County Superior Court website. And that way you can call him and just say that he's been appointed in your case, and there's a quick turnaround report being requested for presentation on November 12th. Anything else, Ms. Powers, that I missed?
We just have 2 clarifications. On the child support order, are you granting our request that it start September?
Yes.
And then on our proposed parenting plan, we included 191 factors. Is the court finding the 191 factor or reserving on the 191?
Let's see, I just had those up to tell you. I'm going to go ahead and at this time, well, I want to reserve on them. I just don't have enough information. There's enough to basically adopt the parenting plan as it's proposed for the other items, but that may change once. So ultimately, I have all the concerns, but I would like the update from Mr. Lawrence before I do it more permanent-like.
Okay, and it is the court adopting our request that Mr. Estes' visitation be supervised by his family until the end?
I'm adopting everything in the report or in the parenting plan except reserving on the 191 factors for now, pending. And so this may change once Mr. Lawrence has an opportunity to talk to you, go to your place, see what it looks like. Same with mom. And then make a recommendation to the court as to what needs to happen, okay?
So how would the supervised visits work? Like, I'm not sure.
So what I would do at this time, because I don't know the schedules of your family, what I would suggest is reach out to Ms. Powers and see if you can figure out just exactly what it is that they're looking to have. Do you have someone in particular, Ms. Powers, that you're looking to have supervise?
We're comfortable with his family. Either of his parents would be appropriate.
So when you have your visitations, you need to have either your parents or someone else from your family there and present.
So where would the visitations take place?
That I would work out with your family. I would also reach out to Ms. Powers to see if they had someone in or a place in mind at the house of the parents, something like that. Whatever, Ms. Powers.
I know that my client is comfortable if the visitation occurs at the paternal grandparents' house.
Okay. All right. So it sounds like your parents' house. Okay. So work it out with them for them to supervise and be present during your visitations.
Okay. That's going to be a little difficult because of religious beliefs. I'm no longer in the congregation that they're a part of at this time, and so they are not nobody from the congregation is allowed to really speak to me or have anything to do with me. So except unless it's like business, I'm sure this is okay, but it just kind of makes for an awkward situation because
So let's do this. If they just say, no, we're not going to.
I know they would say yes. It would just be awkward.
I understand.
That whole thing, yeah.
And I understand, and there may be another option. I just don't know what it is at the moment for me to order something different. So I'm ordering the family at this time. When Mr. Lawrence comes and joins us on the November 12th date, maybe there's another option. If you have a suggestion for somebody else to supervise, talk to Ms. Powers. Reach out to her and just see whether or not you can reach an agreement on things. Okay?
Okay.
Okay.
Thank you, Your Honor.
Thank you.
All right. That concludes the docket.